Do you know where you can experience retirement living at its best? If it's time for you or your parents to start exploring your options, why not come into a Chartwell retirement residence and let our professionally trained staff help you to understand and navigate through the decision-making process. You will find that there are many options to suit your needs, and they will find a solution that's right for you. Why not visit us at Pembroke Heritage Manor, the Pinewood in Pembroke, or Quail Creek in Renfrew, or go to www.chartwell.com.
Seniors in Our Community is brought to you by Chartwell Retirement Residences, Pembroke Heritage Manor, the Pinewood in Pembroke, and Quail Creek in Renfrew. Chartwell Retirement Residences, making people's lives better.
Good afternoon and welcome to Seniors in Our Communities. I'm your host, Marian Aidsness, and we are broadcasting live from Valley Heritage Radio at CJHR 98.7 FM. This show is sponsored by Chartwell Retirement Communities and Valley Heritage Radio, and brought to you by the Alzheimer's Society of Ottawa and Renfrew County, Bonashare Manor Day Program, Care For in Pembroke, Marion Hill Incorporated, North Renfrew Long-Term Care Community Services, and the Home Support Services of Arnprior, Braeside McNabb, Barry's Bay, Calabogie, Eganville, and Renfrew. The intent of this show is to present topics of interest to seniors. Our guests today are Jolanne Horvath, a paralegal who has an office in Renfrew, who was on the show a while ago, and Mike Delwizio, a lawyer who works with Jolanne. Our topics today are powers of attorney, both for personal care and finances, wills, the roles of an executor, some estate planning information. But before we speak with them, we'll have our home support message featuring the Alzheimer's Society of Ottawa and Renfrew County. Their offices service not only Ottawa, that office is located at 1750 Russell Road. The Arnprior office is to be found at 16 Edward Street, Suite 115 in the Kenwood Corporate Centre in Arnprior. The Pembroke office is at 715 McKay Street in the Ottawa Valley Health and Wellness Centre. The Alzheimer's Society provides services in the form of support, education, and resources in all the communities in Renfrew County. Examples of this assistance include the First Link Learning Series, support groups, and public education seminars. There's also fact sheets, webinars, and resource centers with books, videos, DVDs on topics such as coping techniques and strategies or activities for the person with dementia. The First Link Learning Series are free education sessions where families can discuss topics to help them live well. Each session builds upon the learning of the one before. There are certainly upcoming sessions going on across the county. We'll talk about those more in our announcement section. Support groups are offered monthly at various locations throughout the county. Participants share information, learn, and gain support from others. The Alzheimer's program staff are also available to help families by phone or office appointment. Finding Your Way is a provincial program designed to help caregivers prevent missing incidents and crises before they occur. This program is specifically targeted to 8 different multicultural groups. Medic Alert Safely Home is a national program designed to help identify people with dementia who are lost and assist in a safe return home. Renfrew County families are invited to call the Alzheimer's Society for information, support, and education. No one has to cope with dementia alone. Call any of the Alzheimer's Society's office through their toll-free number, 1-888-411-2067. That number again, 1-888-411-2067. 2067. Their website address is www.alzheimer.ca/Ottawa. Before we begin our interview, I want to let our listeners know that this show is the third in our three-part series in which we deal with topics that, as we age, we should be thinking about, planning for, and then even discussing our plans with our families. Maybe this show will be the opening for that conversation with your family to start. Now it's time to introduce you to my guest today. Mike is a lawyer who is an associate with a law firm in Nepean and assists clients with their wills and estates in our area as well. And Joanne is a paralegal working in Renfrew County. She actually referred me to Mike when I was looking for a lawyer to come on this show. Welcome to the show, both Mike and Joanne.
Well, thank you very much for having me on today, Marion.
No problem. Throughout the communities in Renfrew County, there are many lawyers who specialize in wills and estates. And again, the Yellow Pages is one source of a listening for those in Renfrew County, if you've not already found one. But let's talk to Mike a little bit about these topics and a little bit, I think, maybe about yourself first before we get started. Mike, can you tell us a little bit about how long you've been practicing and the law firm that you work with?
Well, sure thing. First of all, I was born and raised in Ottawa, and I live in the Ottawa Valley now. I work as an associate in the business law group at Kelly Santini. So Kelly Santini is an Ottawa-based full-service law firm. Some areas of practice for the firm include business law, real estate, estate planning, and also administration, civil litigation, construction, and employment law. I myself practice in the areas of business law, real estate, and also estate planning, and I'm looking very forward to talking about it today.
Good, great. The first topic I think we'll start with is powers of attorney, perhaps, both for personal care and finances. Can you tell me what the terms mean for those that perhaps haven't heard of them before?
Absolutely. A power of attorney refers to the act of appointing someone to act on your behalf. So you are appointing someone to act on your behalf as a fiduciary, meaning that they have a very special standard of care that they have towards you. So this can be used if someone is incapacitated or if someone is simply unavailable in certain circumstances to do something on their own behalf. So there are two different types. The first one is a power of attorney for personal care. So as the name implies, this deals with health care and other medical decisions. So someone is giving someone the ability to make decisions on their behalf to either allow medical treatment or also to decline medical treatment. The second one is powers of attorney for property. When you appoint someone in this fashion, you are allowing them to potentially deal with all other matters that you could do as an individual. So as an example, deal with your financial matters.
Okay, great. Why and how should we delegate this authority?
Okay, well, let's deal with the why first. First of all, it's important so that decisions can be made in a timely fashion. If someone's unable to make a decision for themselves, it's nice to have someone who has been appointed ahead of time so that they're able to step in to make those decisions right away. Also, the choice of who acts on your behalf, it's nice if you can make it ahead of time. People obviously want to choose who's going to be making those decisions for them. And if you haven't appointed someone to be your attorney, then there's no guarantee that who you assume would be acting on your behalf will in fact be the person who is doing it. And finally, the process for installing someone as an attorney after someone is already mentally incapacitated it can be time consuming and quite costly, so it makes sense to do it in advance.
In advance, okay, great.
So how to do it now?
Yeah.
There's really only one way, and that is you have to have a special power of attorney document drafted, and then you have to have it executed in a very specific way. All powers of attorney must be in writing.
Okay, good. And they're two separate powers of attorney, right? For personal care is one and for property is the other.
Correct.
Okay.
So you have two separate ones, and you can have two different people or a group of individuals acting on your behalf for those two separate things.
Okay. Now you spoke about what happens if there isn't someone that's delegated. At that point in time, then someone else is delegated if you've not done powers of attorney, and therefore not perhaps someone that you would want to be making those decisions for you.
That's correct. If you do not appoint someone through a power of attorney, then if someone wants to act as attorney, they have to make an application to the court under the Substitute Decisions Act.
Okay.
And again, as I mentioned, this can be quite a time-consuming process. This scenario really should be avoided at all costs if possible. And by doing that, that's why you should be drafting your power of attorney.
So you can't just assume that your spouse or family would take over and make those decisions at that point in time?
You could assume it, and in many cases, as a practical matter, some spouses end up effectively making some decisions, but it's not a guarantee.
Right.
In order to have it sort of officially done, you need to have an assessment done by a licensed professional, and there's several processes, and like I said, applications that have to be made to a court in order to have that bestowed upon you.
Okay.
And again, sometimes the public guardian trustee of Ontario could also become involved in certain circumstances.
Okay. Interesting. A good thing to plan for before the fact.
Unquestionably, yes.
Okay. The powers that these documents do give to the person who accepts the role are wide-reaching, I would assume. What kinds of things? Decisions at a hospital, decisions other places that they would make on your behalf?
You're absolutely right. They're incredibly far-reaching. So how about we deal with one first? We'll deal with powers of attorney for property first, or for finances, as we've referred to them earlier. The Substitute Decisions Act specifically provides that an individual grantor may authorize an attorney under a continuing power of attorney to do everything in respect of property that person as a grantor could do or is capable of doing, except to remake a will for that individual. So the powers really are far-reaching. So anything from dealing with finances to dealing with the utility companies to dealing with real estate potentially. It's almost a limitless amount of things that attorney can do on your behalf. Okay, now keep in mind that's not a requirement. So someone who is granting a power of attorney can also limit the scope of what that attorney can be used for, what that document can be used by the grantor to do. So as an example, if someone wanted to give someone just the ability, as an example, to deal with real estate because they're not feeling well or they're going to be out of the country, they could appoint someone to just have the power to deal with a very specific piece of real estate for a very specific amount of time.
Okay.
So there's not a requirement that you give everyone all that far-reaching power. You are able to give different people specific powers for very specific things.
Okay.
Now,
sometimes there's multiple people that are appointed as powers of attorney too. Is that a good or a bad thing?
Well, it can be a good thing and a bad thing for various reasons. So sometimes there can be a requirement why you want to have more than one person rather, act on your behalf. So as an example, an individual may have one or two or three adult children, and we don't want to say freeze one child out of making those decisions.
Right.
So it can make sense to have more than one person on there. It acts as a check and balance as well, because everyone many times will have to agree about what the treatment will be or about how assets or something is to be dealt with. Now, of course, there's some risk there as well, as you can imagine. So, if the attorneys are not getting along, if there's a disagreement, we have to think about how we're going to deal with that. And again, that's something that people should just be aware of. So when you're granting this, you should think about, if you are appointing multiple attorneys, what their relationship with each other is.
Okay. How are you going to know when it's time to activate the power of attorney that you've been given? Is that a decision that's oftentimes very clear-cut, or is it muddied, or what happens?
Well, there can be a couple different scenarios when it's going to be required for someone to exercise this power. Okay, so the first one could be outright if you were asked to do so. So as I mentioned, some powers of attorneys are drafted in such a way that they can be used immediately. So someone may give you a power of attorney, and they may say, I would like you to act on my behalf because I'm going to be unavailable to do so at a certain point to act on my own behalf. Please do so. So that would be one time where it could be used right away. You also have these ongoing, continuing powers of attorney. And the question then is, when do we use those? Those can also be drafted in two separate ways. So some of them, and this is typical when you have spouses that give them to each other, they can be used right away out of convenience. So if your spouse was incapacitated for some reason or simply unavailable to act on their own behalf, then you, as someone that was appointed as an executor, could start using that document, on behalf of that person. There's another way that these can be drafted, and it really just depends on what an individual would like. You can have these power of attorney documents drafted that says, they can only come into force and only be used if the person who is granting that power is deemed to be mentally incapacitated. So there's a test there, and there's someone who has to be able to do an assessment that says you are mentally incapacitated, you're unable to make your own decisions, and it would be then that attorney who's been appointed could act on that person's behalf.
And usually, who is it that declares someone incompetent or incapacitated?
It has to be a doctor who is licensed to make that assessment.
Okay, like
Correct.
a family doctor or...
Typically, that's who it is, but not all family doctors are. However, an attorney could suggest that it could be a different party. But typically, it would be someone that is able to make that assessment. And again, that's a very special licensed individual.
Sure. And then you know then that your power of attorney had taken over and then is able to make decisions on your behalf from that point on?
Yeah, in that circumstance, if you had an opinion from that person, they were mentally incapacitated, then so long as you have that that document, you could start certainly acting on someone's behalf.
And usually when you draw up that document, do you then give a copy to the person you're giving that power to, or do the documents stay within the individual's keeping?
It can vary, and it will vary on the individual circumstance, and also, frankly, depending on who your lawyer is. So many times people will want to have one right away to give to their attorney, or they may ask that it be kept by their solicitor until such time as there's a need for it, or someone presents something to them saying this person has been found to be mentally incapacitated. So that is a very good discussion to have with your solicitor if you're having a powers of attorney drawn up, to discuss if you'd like to have one right away or if you'd like to have them kept. Okay, interesting. And a lot of little things to think about as you go through that process. I'm sure that a lawyer would help you, the what ifs and that kind of scenarios that then you're making a decision that would work it's
for
exactly
whatever your situation is.
Many times the documents are not overly complicated per se, but what can be sort of difficult and time-consuming is having someone ask all of the right questions to make sure that simple document or relatively straightforward document is the one that is best suited for you. Okay.
And those powers of attorney can only be drawn up with a visit with a lawyer, or are there other ways to do those documents as well?
Well, I do know that some government agencies do have them available online, and you can fill them out. Okay. Again, it's tough to have them tailored for your specific need at that point. There is no inherent requirement that you use a lawyer in order to draft them. Okay, but there is, I would suggest, more risk that they may not be executed properly, or that they may not serve your purpose as correctly as you may hope by not having them professionally. Yeah, I'm a biased opinion, though, Mary.
Well, certainly, yes. Being a lawyer, you would know that. But I've heard of banks or financial institutions being very picky, oftentimes, as to the powers of attorney that they will accept. So perhaps that is one reason to be making sure it is legally done well.
Yeah, that's a fantastic reason. And also keep in mind that some banks have their own forms of power of attorney that they will request that you sign as well. And you should be very careful when you read those to make sure that you're not being asked to revoke other powers of attorney that you might have done at a previous time. So I would suggest anyone filling out any of those forms at their bank to read them very carefully. If you have any questions, to bring them to your lawyer just to look over to make sure there's no issues with them.
Okay. Now, in general practice, can you think of any mistakes that powers of attorney for either personal care or finances make when they go to activate their powers?
Oh boy, yes. Absolutely, quite a few. Well, the first one is not doing one. Okay. You should have one. By not doing one, there's, like I mentioned before, there's just quite a bit of risk, and it can cause quite a bit of hassle when in fact one is needed. And I see many times in my office people coming in when it's almost too late to have one done, and they're scrambling to have it done. It would have been nice if they were able to sort of plan
ahead.
Absolutely. Okay. Another big one is appointing an inappropriate person to act on your behalf. So it can be a very difficult question for someone as to thinking, who is it that I would like to be making these important decisions for me on my behalf? A couple things that I recommend personally to people is be wary of appointing people that are far away from you. So you may have a sister that you trust very much and is very capable, yet if she lives across the ocean somewhere else, it can be very difficult for that person to act on your behalf and do all the things on a day-to-day basis that need to be
done. Okay.
Absolutely.
Understandable.
you need to be careful about, again, you may trust someone then, they may be close by, but they may not be necessarily capable of managing your affairs. So keep in mind, this person could be responsible potentially for dealing with your investments, paying the bills, all of your bank accounts, anything of that nature. So you have to make sure that they're intelligent, trustworthy, and again, capable of taking on that task.
Okay.
And the final thing I'd say to watch out for in terms of people is making sure that whoever you appoint wants to act on your behalf and doesn't mind being given that responsibility.
Because it can be a big responsibility, right? And it'll take a lot of time, perhaps.
It can be a huge responsibility, depending on what the needs are of the person and how the size of their estate. So there's nothing more heartbreaking than having someone take the time to do a power of attorney and then have that attorney say, you know what, I'm not interested in acting for you and I'm going to decline to do so. You can't force someone to act on your behalf. So a good idea to make sure the person wants to be acting as your attorney.
Okay.
And if I could add one more thing as sort of a third mistake that people commonly make is if people are doing their own document, you have to make for certain that it's being executed properly. Okay, if you just at home print off a document and sign it and date it, it doesn't necessarily mean that it's valid. Okay, if you look on some of these sites or if you talk to your lawyer, they'll know how it has to be executed. So as an example, with 2 different witnesses that are signing, if you just simply prepare one on your own and sign it, it doesn't necessarily mean that it's valid. There's certain rules and protocols that need to be followed.
Okay, great. Some good pointers there on powers of attorney. Why don't we move on to wills? Again, another topic, though, or another function that a lawyer is a good idea for you to have one to do that with. But what details can you tell me in general that need to be included in a will? I'm sure there's some more specific than others, but the kinds of things that usually do go in a will.
Sure. Well, I'll keep it very broad. There's sort of 3 categories, I would say, that really you want to deal with inside of your will. So the first one is who is going to be your executor or trustee. And what I mean by that, for anyone out there that doesn't know, is the person who's being tasked with carrying out all of your wishes and dealing with your estate once you have passed away. So it's very important to say who is going to be this executor. And potentially, if this person was unable or unwilling to act on your behalf or behalf of your estate, who would be an alternate executor to act in that circumstance. So that's the first one. The one that everyone thinks about, and this is a very broad category, of course, is then how is your estate to be divided? Who would you like to have certain items? Would you like to have certain amounts going to certain people? Is it conditional upon certain events happening? What happens if someone's already passed away by the time you pass away? There's many things that need to be thought of. But that's a big one, and really the main purpose of the will is to figure out where you'd like all of your assets and the whole of your estate to go. And then finally, for those of you that have any sort of minor children, you want to put an appointment to the best of your ability, what your wish would be of where you'd like your children to go in terms of guardianship and things of that nature. People are obviously very concerned about that when they come in to do their wills.
Right. Okay. So those 3 different areas is what you discuss and then have plans around.
That's right. I normally have a very detailed conversation with clients, and then from there we figure out what the best course of action is. Okay, interesting. And I guess when someone is preparing for that visit with the lawyer, then those are the things you should think through before you go and have some ideas of what you would wish. That's right. A lot of lawyers will send you a list ahead of time saying, I would like you to know A, B, and C. So common ones are if you have real estate, how that real estate is held, because there's different ways that real estate can be owned. Typically, lawyers want to know if you have insurance policies, who your beneficiaries are on those policies. They also want to know if you have registered accounts, RSPs, RIFs, things of that nature, if you have beneficiary designations on those, because some of those things can fall outside of your estate, and all of a sudden your will doesn't capture them, depending on how those are listed. Okay, and there's probably got to be a checklist somewhere or other on that big internet out there that one could use from time to time when you're thinking about these things. I don't think it would take too long if you were to search online. I'm sure you could. Yes. Okay. Oftentimes there are other ways to draft a will that I've certainly heard others talk about. How valid are they? The same as you had talked about with powers of attorney? Would those be the same
kinds of cautions you'd give, or are there other things you'd like to say about that?
Well, I do caution anyone who's trying, again, to draft their will and execute it on their own. So there are requirements for how a will needs to be drafted in terms of witnesses and things of that nature. However, I think what you're referring to and what people often think is what's called a holograph will. So in Ontario, it is possible to make a valid will entirely in one's own handwriting. That's important. And they need to have their signature at the end of the will. So such a will requires no witnesses or other real formalities of any kind at execution. So even though this can be done, again, it can be done in your own handwriting, signed and dated. I mean, it's rarely advisable to do this sort of will, and I would suggest you would really only want to use it in emergency situations. But unless a holograph will is used, unless someone has written it in their own handwriting, it has to be typed, signed, initialed, witnessed by, again, 2 different witnesses in accordance with some prescribed wording.
Okay.
And it's worth noting as well, executors, beneficiaries shouldn't be witnesses of those wills. So again, a holograph will, yes, can be used, but it wouldn't be my first choice for people out there.
Okay. And I guess it depends, too, on the family situation or the executors that are available and that kind of thing. How complicated the will would be or the estate would be and some of those kinds of considerations, too. Yeah.
Of course, no 2 families are the same. And I would imagine for someone with a large estate or a very large or sort of complicated family situation, it would be darn near close to impossible to draft a very effective holograph will.
Okay. What about an average cost to draw up a will? Is there a general or an approximate or a...
Well, now that's a difficult question.
Okay.
I would say it would probably vary wildly, depending on your firm that you're dealing with, the lawyer, the city in which you're in, how large and complicated the will and the estate is. So let me first preface everything by saying that I would say to expect to pay at the very least several $100s to have a will and powers of attorney drawn up. So, if it was under $300, I mean, that would be on the very low side. And again, it can easily get into sort of 4 digits depending on, again, the size of the estate. If you have a couple, if you're doing more complex estate planning strategy. So again, what I've said there is the absolute basement, depending on where in the country you may be.
Okay. What about where we should keep this will of ours?
Well, another good question. My number 1 suggestion would be to keep it with your lawyer. That is the easiest, typically most foolproof way of having it dealt with. It helps prevent damage, loss, and also tampering, which people don't think of. A reason for that is that if you keep your will in your house and the first, if something happens to you, the first person to find it may read that will, and if they don't like what they see, sometimes that will can just disappear, and we'd hate to have that happen. So by leaving it with your lawyer, like I said, it prevents it from being tampered with, stolen, lost, damaged, anything of that nature. However, if you do want to keep it, and some people do, you typically just want to keep it in a safe place where your executors would have a reasonable chance of finding it. You may want to let your executors know. And further to that, if you are going to do that, you may want to keep a true copy of that will with your lawyer in case something were to happen to it. They have evidence of what your last will did in fact look like, which can be used as evidence in court if the true will cannot be found.
Okay.
I typically don't recommend keeping it in a safety deposit box, only because it can be difficult to get into that safety deposit box. People may not even know that safety deposit box exists.
Yes. Yeah, no, and all those things. And again, I think when we talked a few weeks ago with the gal that came from the funeral home, when we were talking about pre-planning funerals and things, to have access to those documents at any point in time is a good thing, not having to wait until the weekend's over or the night's over or those kinds of things, because that certainly is a document very early on that needs to be looked at.
Well, time is of the essence. Yes. Absolutely. Yes. And it's in that will that's going to state who is in charge.
Yes.
So who should be making these plans and who has the authority to make those decisions.
Exactly.
So you're absolutely correct.
Okay. Conversations then again with our family or executor when the will is drawn up is probably, I would think, a good idea, so that everybody is on board and knows what your plan is for your estate.
I typically recommend it in that I like communication between family members. There's not an inherent need to keep everything secret. And specifically, if you're drafting a will, I would let your executors know that it is your intention that you name them as executors. Because again, nothing can really mess up your plans worse than having the very first thing you say that you want this person to be an executor fail because that person does not want to act on your estate's behalf.
Okay.
So certainly I'd recommend talking to your executor. Keep in mind for people, though, that there is no obligation to discuss your will with anyone else, including those beneficiaries. No one has a right to anything in your estate, and you may not wish to discuss those distributions with those beneficiaries. And again, there's nothing written in stone because up until the time you pass, in almost all circumstances, you can redraft that will and change it. And sometimes by discussing it, people start to feel some entitlement, or they can start to cause sort of potentially arguments between your family. So that is up on a sort of a case-by-case basis, I would say, more so. But for your executors, certainly let them know.
Yeah. Okay. And there's got to be, I would think, a checklist for executors at some point in time that would be easy to access too, so that one that has been appointed has an idea of what they're going to be doing on that other person's on behalf.
Yes, I'm sure there's plenty of them out there. And for anyone who's had to be an executor or trustee of an estate, chances are your lawyer's going to have a very detailed list of things you should be doing. And actually, a lot of funeral homes now have people that are acting as a consultant or a director to tell you some of the everyday things that you should be doing to start to deal with an estate. And I've dealt with them in the past. They're excellent. So make sure you ask about that when you're at the funeral home.
Sure. Okay. How often should we review or update the will, besides at times when you're want to change your mind and change something in it?
I would like to think that you would at least want to blow the dust off that will and take a look at it every 5 years, just to review it, to make sure that everything in there is still correct and that you haven't changed your mind about anything. And of course, as you alluded to, it should be updated as life events occur. So if you are married, your will, if you have one, becomes null and void right away. So you should be doing a new one at that point. If you get a divorce, if there's a birth or a death in the family, or of a beneficiary or executor, or if there's significant changes in your financial position, these are all great reasons to go in, take a look at it, and see if you need any updates.
Okay, great. Okay, now let's move on to maybe some more things that are more included in the estate planning kind of thing. Oftentimes, I think there's assets that people in property, I think I've heard conversations more so about things like cottage property or even a home, I assume, that you might want to have specific requests around, or think about how that would get divided up to your different folks who decided to do it. Any advice in those kinds of property items?
Sure. Well, cottages can cause quite a few issues in a family and as part of estates. On the most basic level, we talked about communication earlier. Sometimes it can be as simple as people talking to their children or beneficiaries and seeing if everyone would actually like that cottage, because sometimes it's not everyone. Sometimes it's just one child or beneficiary that would like that property, and all of a sudden it's problem solved. Another thing people should be looking at, and I think it might have been potentially dealt with last week, is for things like cottage properties, lots of times there can be a pretty big tax bill there, a big tax liability for capital gains and things of that nature. So you may want to look at purchasing insurance, which can cover some of those gains. You can start paying that tax bill off ahead of time. And what that does is it makes sure that property doesn't have to be mortgaged or sold in order to complete the administration of the estate. There's also the opportunity or the option to prepare a cottage trust, which is becoming, I'd say, a little more prevalent. It can be it can be fraught with a couple things to think about as well, and potentially some drawbacks, but it is something that if you are going in to do your estate plan, maybe ask your solicitor about it, and they can discuss with you sort of some of the pros and cons around that. But it is an option for you.
Okay. Other advice in property areas?
Well, a big one would be to think about tax implications when dealing with any asset. Some of them deal with other things than others. Some of them have different tax liabilities associated with them. And then, again, a basic one, and some lawyers do this, some don't, and people that draft their own sometimes don't think of it. If you attach dollar values to certain things, that dollar value can be eroded over time. So someone may say, gee, I'd like to give each grandchild $100. Well, 40 years ago, that was great, and it sounded like a big amount of money. Nowadays, not so much. So sometimes I advise them to think in terms of percentages, which is
rather than dollars.
That's exactly it, because how much money you have to give may change over time, but the percentage will always basically remain the same in terms of how much you'd like people to have. So that's just a general piece of advice, and when I meet with clients, a lot of them haven't thought of it that way.
Sure. Okay, well, I thank you for that. Okay, now let's talk about the role of the executor in an estate, and certainly, hopefully, the executor you've chosen decides that, yes, they'll carry out that function for you. What kind of role do they play? What kinds of things do they look after?
Okay, well, if someone has a will, the role of their executor, frankly, is to carry out the instructions that they have laid out. And in the event that there was no will, so if someone dies intestate without a will, they have to deal with the deceased property in accordance with relevant legislation here in Ontario. Okay. In terms of other responsibilities, though, there are quite a few, and being an executor can be a tough job. I mean, it's not always pleasant, and there is a lot of responsibility there. So some common responsibilities: one, you have to ensure that taxes are filed and paid on behalf of the estate. Executors need to remember that they're personally liable to make sure that everything is completed on behalf of the estate. So file your taxes and pay those taxes. You also have to look for debtors, or rather I should say creditors. So you have to look for the debts of the estate to see who may be owed money, and you have to make sure that they get paid before you can give out any gifts of any nature and kind to any different beneficiary. You also have to make funeral arrangements. Now, what people don't know, a lot of people, is they want to put their funeral arrangements in their will, and you can do that, but it really is up to your executor. So anything that goes into that will is not a requirement that it happens. It is completely up to your executor about what happens at your funeral. So if you do have very specific wishes about what you'd like to happen at your funeral, I'd recommend speaking to your executor ahead of time about what your expectations may be. A couple other things. Your executor has to talk and communicate with all the beneficiaries to let them know what their share of the estate will be, and has to advise them of what share they may be receiving. And then finally, you have to distribute those assets. So you have to make sure that the distributions are given out as they've been asked to be done in the will, or again, pursuant to legislation.
Okay, so that is, yes, a big job.
A very big job, yeah. Yes, indeed.
Do you oftentimes see where there are more than one executor, or that two people share that responsibility? Or
it's not unusual to have two executors at all. So similar to what we talked about for powers of attorney, people may want to have more than one person. They may have a couple people they trust, or more than one child or individual, and you're sharing the responsibility there. So much like someone who's acting as your attorney, it acts to me as a check and a balance to have two people have to sign off on certain things before they're done. Okay. So again, you have to look at it on a case-by-case basis. Nothing wrong with it. In many circumstances, I think it can be a good thing.
Okay. Probably, again, the distance that an executor would live from where the estate is and all those kinds of things would have an impact too.
Well, sure. If your executor lives in Dubai, they're going to have a hard time cleaning out your garage to get everything done. So, absolutely. Yeah. Okay. You have to think about that. Interesting.
Other information you might want to tell us today, Mike, about any of those topics?
Sure. Just a couple things, actually. I'd already mentioned, at least for administering a estate, make sure that you do talk to your funeral home director or consultant, because I think they're fantastic. If you're administering an estate, keep really good records. I mentioned that you're personally liable for what it is you do, and that goes for anyone acting as an attorney, because you do have a fiduciary duty to the person that you're acting for. And also as an estate trustee, you have a real obligation to that estate, and people can hold you accountable for what you do or do not do. So make sure that you keep very good records of what it is that you're doing, in case you're ever called upon to display why it is you did something, or where the money went, or what happened. So there's nothing wrong. You cannot keep records that are too detailed or too good. Okay. And then finally, if you need to speak to an accountant or a lawyer, if you have questions, do not hesitate to do so. You are entitled to charge the estate for work that is performed by professionals. And again, because you are going to be held personally responsible for what you are doing there, it's nice to have the proper advice so that you know how to govern yourself and how to act.
Okay, great. Okay, I think maybe at this junction we'll bring Jolanne in to give listeners a little more information on how to contact Mike or herself in this area.
Hi, Marion. It's nice to speak to you again.
Yes.
I am the contact information for Mike. I work throughout Renfrew County. The business is called Avalon Legal Services, and Mike DeLuisio is a lawyer who comes into my office once or twice a month. We'll book appointments with him, and you'll be able to have a half-hour free consultation with him and speak to him about any of the questions or concerns that you have. If you need to contact us, our number is area code 613-432-7219. Again, it's area code 613-432-7219. And we also have a website that you can contact us through. It's www.alspc.ca. And any information that is sent through the website will actually come directly to my email. Mike, I don't know if you have anything else that you'd like to add, how we work together?
Well, I can also add one other thing about how to get additional information. You can also go to our firm's website at www.kellysantini.com, and there's some additional information on there with respect to estates and wills and that sort of information. And Jolanne's already talked about for anyone in the Ottawa Valley about how to get in touch with us. Happy to assist.
Great. Okay. Well, I want to say thanks to both of you for taking time to come in today and sharing your expertise with us. Certainly, when Jolanne was on the show a while ago, she made it very clear that as a paralegal, she couldn't talk about those things, but she did know a lawyer that would come in and talk. Well, so it's nice of you to come in, Mike.
Thank you for having me.
No problem. We're now going to break for a commercial, and then we'll be back with our announcements.
Beginning, worrying about an aging parent being alone can be a source of anxiety for family caregivers. Chartwell's Guest Stay program is designed to offer short-term accommodation and temporary support. This includes a relaxed environment, healthy and nutritious meals, and access to on-site services. You'll gain peace of mind, and your loved one will have the comfort and convenience of being in a safe and secure Chartwell retirement residence. To learn more about Chartwell retirement residences in the Ottawa Valley, visit chartwell.com or drop in at Chartwell Pembroke Heritage or the Pinewood in Pembroke or Quail Creek in Renfrew. Their caring staff would be happy to assist you.
We're now back with you, and I have quite a few announcements for you this week. The first one we had mentioned a couple of weeks ago is from the Calabogie and Area Home Support Office. They're participating in the Festival of Scents, which is an annual event organized by the Calabogie and Area Business Association. The theme this year is A Sense of Caring. The event will be held Saturday, October the 5th, or if it's raining, it'll happen on Sunday, October the 6th, from 10 until 2 p.m. at 5056 Calabogie Road in Calabogie. They invite anyone interested to participate and might wish to sell their wares, whether it's crafts or collectibles, to rent their tables from the Home Support Office there. The tables are $10 each. Sales certainly go to the participants, but the Home Support Office benefits from the table rentals. To arrange for a table rental or ask additional questions, you can call Jane at 613-752-2828 between 9 and 12. Monday to Friday. The next announcement is coming from the Renfrew and Area Seniors Home Support and the Arn Prior Braeside McNabb Seniors at Home program. Jointly, they're hosting a community dance on Saturday, October the 19th at the Horton Community Center, featuring the band called Smoky Rose, starting at 8 p.m. The cost per ticket is $10. There'll be a light lunch served, as well as door prizes and spot dances. Tickets are available at the Aikenheads Drugstore in Renfrew, at the door, or by calling the Renfrew Seniors Home Support Office or the Arn Prior Braeside McNabb Seniors at Home program. The Renfrew office number is 613-432-7691. And the Arn Prior office is 613-623-7981. The next announcement I mentioned earlier is a reminder again from the Alzheimer's Society about their fall learning series. There are still quite a number of ones going on throughout our area. If you want more information about them and where they're located, simply call their office at 1-888-411-2067. Also an announcement from the Quail Creek retirement residents here in Renfrew, inviting you to their Autumn Harvest Open House. It's happening Sunday, September the 29th from 2 to 4. Come and join them and discover how they help provide a happier, healthier, and more fulfilling retirement lifestyle. Enjoy the delicious flavors of autumn, including warm, complimentary apple cider, homemade apple pie, and entertaining music. Again, that's Sunday, September the 29th at the Quail Creek Retirement Residence. There also is another public education seminar that's coming up Wednesday, October the 9th at the Gem Hall at the Groves Park Lodge here in Renfrew. A couple of topics that they will be discussing, and this will be a morning seminar that the public's invited to. The first two speakers are talking about caregiving. Bonnie Schroeder and Beverly McIntosh. A caregiver is someone who supports a family or friend in need with ongoing assistance. This workshop will appeal to anyone interested in learning more about caregiving and the work of the Ontario Caregiver Coalition, and will offer a personal reflection of caring for a spouse with dementia. The second part of the morning is understanding disenfranchised grief and hidden loss. Grief is a reaction to all kinds of losses, not just death. Disenfranchised grief occurs when an individual's loss is not publicly recognized or acknowledged by others. Because their grief cannot be shared, the grievers face special pain and problems that can result in complicated grief. This session will also address some important issues around care for the caregiver. Again, to register for this public education session, you need to call the number 1-866-994-8124 and ask for extension 5914. Chantel Barr at the CCAC will be taking your call. And I think that's it for our announcements today. Quite a few things going on around the county. Hopefully some of you will take time to attend them. This weekly radio program is brought to you by the Alzheimer's Society of Ottawa and Renfrew County, Bonashare Manor Day Program, Care For in Pembroke, Marion Hill Incorporated, North Renfrew Long-Term Care Community Services, and the home support agencies of Arnprior, Braeside, McNabb, Barry's Bay, Calabogie, Eganville, and Renfrew. Our sponsors are Chartwell Retirement Communities and Valley Heritage Radio at 98.7 FM. I invite you to join me next week when my guest will be Steve Osipenko from Horton Township. We're going to talk about emergency preparedness. Until next week, I hope you stay well, keep enjoying our beautiful fall weather, and don't forget to tune in next Tuesday for Seniors in Our Communities.
Do you know where you can experience retirement living at its best? If it's time for you or your parents to start exploring your options, why not come into a Chartwell retirement residence and let our professionally trained staff help you to understand and navigate through the decision-making process. You will find that there are many options to suit your needs, and they will find a solution that's right for you. Why not visit us at Pembroke Heritage Manor, the Pinewood in Pembroke, or Quail Creek in Renfrew, or go to www.chartwell.com.
Seniors in Our Community has been brought to you by Chartwell Retirement Residences, Pembroke Heritage Manor, the Pinewood in Pembroke, and Quail Creek in Renfrew. Stop by today to have a personal visit and a complimentary lunch at a Chartwell residence near you. Chartwell Retirement Residences, making people's lives better.